Hello, and welcome to Ipsy Dixit, a podcast on legal scholarship. I'm your host, Lu Nguyen. My guest today is Chris Sagers, James A. Thomas Professor of Law at Cleveland State University, a member of the advisory board of the American Antitrust Institute, and a fellow at the Thurman Arnold Project at Yale Law School. Today, we will discuss his book, U.S. v. Apple, Competition in America. Welcome, Chris.
Thanks, Luce.
Let's begin by talking about why you wrote this book and what the main argument behind it and the driving force for writing it was.
Yeah, okay, good. So the book on its surface is about one particular case, but it grew to be about a whole lot more than that. And when the case first came out and I first started writing about it, I didn't know it was going to be a book, and I didn't know it was going to be reach the scope that it ultimately did. So the case was famous in its day. It was a Justice Department antitrust lawsuit against the Apple Computer Corporation and several publishing companies for fixing the prices of electronic books. The complaint was filed in 2012, went through full trial on the merits and appeal to the Second Circuit. In 2013, the government pretty much won the whole way. What was remarkable about it, though, was something kind of unexpected. When the case was filed, when the complaint first became public, nobody really knew too much about the case. It was the subject of a non-public investigation by the Justice Department, and people knew that it was going on, but I don't think very many people knew too many details. And then when the complaint came out, it was a little sensational. I mean, it was kind of amazing the range of conduct alleged in the complaint against a bunch of very sophisticated corporate executives, the kind of people that we expect to understand antitrust rules and not to engage in this kind of conduct. And one of those people was very sophisticated indeed. It was Steve Jobs of the Apple organization. But to that extent, it really just made it seem like an easy case. So to that extent, I suppose, in and of itself, the case might have seemed a little boring. And to antitrust lawyers, surely it seemed like a slam dunk. It was the kind of case where if the government could prove the facts that it alleged, it couldn't lose. So what was interesting about it, though, and really I've been fascinated by it ever since in the entire 7 years since the case was filed, was that the case seemed easy to antitrust lawyers, but it did not seem easy to a lot of other people. And in fact, people all across the political spectrum really were very critical of the Justice Department for filing this case. And so, early on, it occurred to me there has to be something interesting about the fact that the broader public is seeing cases like this so differently than the antitrust bar. Something is wrong. Somebody's looking at it improperly, one or the other, and there has to be something interesting to say. So over time, the case just seemed to the subject rather seemed to grow and grow. Became clear pretty soon that it really wanted to be a book, and kind of became about things much broader than just the one case itself. So, ultimately, the argument in the book is that Apple is not alone among antitrust cases in posing a lot of difficulty for the sort of broader public. It was one of many cases throughout history that turn out to have seemed to the public like maybe enforcement of vigorous competition wasn't the right idea, or there was something special about the circumstances, or whatever. But for one reason or another, found a lot of difficulty attracting popular support. And that was pretty interesting to me, because I happen to think that our antitrust policy has been pretty frequently, pretty consistently disappointing. And I think more than anything, it has failed to live up to its aspirations because it has had difficulty generating popular support. And the more I thought about it, the more I thought there's something about the Apple case that is pretty illuminating about all of that, because the arguments that people all across the ideological divide seem to be coming up with to argue that the government shouldn't have brought the lawsuit that it did, they mostly boiled down to arguments in one way or another that there was something special about this case, that however desirable competition might generally be, however desirable free markets might be, there was something about these circumstances that surely required clemency from the ordinary rules that govern other businesses. But the more I thought about it, the more it seemed like all of those arguments really were arguments I have heard before. And in fact, there are come from a relatively short list of arguments that have been made in all kinds of antitrust cases in all kinds of industries, all throughout the history of the law. And in fact, the more I thought about it, the more it seemed like there's never been a defendant that didn't think its market was special and that it ought to be able to do things that nobody else gets to do. So in the end, I mean, this one sort of easy case, a case that on its surface is almost mundane, really, seemed to me to capture the biggest picture problems of all, the biggest problems in the having of a competition policy. And that biggest problem is that even though we generally say in America, we are said as Americans to believe in free markets more than like anybody in the whole world. And most of us, even in times like these, when some people have a lot of doubts about capitalism and this and that and the other thing, I think that generally it can still be said that by and large, most of us are pretty okay with private enterprise and think that to some extent, competition is a good thing. Markets ought to be competitive. And we kind of believe in that as our way of life. And yet, when individual cases pose the hard problem of forcing us to look at competition in its actual operation, we have a lot more trouble believing in that. So the bottom line for me in the book was, look, the problem with antitrust is even though we Americans believe or profess to believe in free markets and private enterprise and the use of competition to limit aggregations of private power, even though we talk a good game about that, the truth is we don't really believe in markets at all, and we don't believe in them in a way that's actually necessary for an antitrust law like the one that we've got to work consistently and durably. So that's the bottom line in the book, and I think it is all actually pretty well captured in a careful case study of a case like Apple.
So can you talk a little bit about the relevant history up to this moment and why is it important?
Yeah, okay, so sure. So here we are in 2019. Our antitrust law is an old law. It's one of the oldest federal statutes still in force. It's 130 years old nearly. And it also has, for much of our history, has held a special place. I mean, a special political place. Antitrust, less so now than it used to be, but antitrust has always gotten sort of a special political deference. I mean, it is among our laws, it's one that we all tend to claim is important. And yet, as I think most people now sense, the law is in some trouble. It is not enforced very vigorously. There's some serious doubts, serious disagreements about how it should be enforced, what its goals are, what it should be used for. And so by this latter day and during the time in which the Apple case was unfolding, antitrust has become pretty moribund. So, the history by which we got to that point this has all been talked about a lot in the last several years, because, I mean, to my surprise, antitrust became a topic of pretty popular discussion in the last 5 to 10 years. So we hear, obviously now we hear every single day that the government or private plaintiffs or somebody is going to break up the big tech firms, and we hear discussion every day about whether big tech is a problem and whether the antitrust laws are up to it and so on. So we hear about it a lot now, and we all, I think, are familiar with in loose terms, with the history by which the law has come to be underused. The short version of the story is that modern antitrust, which was a vigorous and pretty robust policy, found its origins sometime in the 1930s, sometimes around World War II and in the post-war years. And it was vigorous and pretty effective for a while. There were certain dissenters, though, who started questioning whether it was doing the things it was supposed to do, what its goals really ought to be. Starting, as the story's often told, this starts in the 1950s, mostly amongst economists and lawyers associated with the University of Chicago. They grew in influence, and they argued various things, but they mostly argued that antitrust law, which up until that time could be characterized as having not been very rigorously economic, that is, not driven necessarily by careful theoretical thought from an economic perspective about what the actual impacts of various challenged actions might be. They said that law ought to be reconsidered, and we ought to be more careful and think about things more from an economic point of view. They grew in influence, and perhaps more importantly, even than the theoretical developments that they drove, were certain political events of the early 1970s, and above all, Richard Nixon appointed kind of a large number of Supreme Court justices. He appointed 4, which historically is a lot, especially for a president who didn't serve 2 full terms. And it turned out that he appointed enough justices to switch the balance, to swing the balance of the court. So during the 1960s, which was kind of the high point of extremely vigorous antitrust enforcement, the Supreme Court, under a majority led by Chief Justice Earl Warren, had formulated very strict antitrust policy in a variety of areas. The Nixon appointees began systematically taking that apart, starting as early as about 1974, in a series of decisions, basically reversed what the Warren Court had done. For better or worse, however you want to feel about it, there's not much debating that the law changed radically starting in the mid-1970s. And so what had been the most pro-enforcement antitrust court in American history, really within just a few years, turned into the most anti-enforcement antitrust court. And the lower courts, as they must do, they followed suit. So it became harder and harder and more expensive to enforce the antitrust laws. And so they came to be less and less enforced. And so fast forwarding a little bit to the modern day, we now are in a situation in which antitrust is not a lot of cases are filed, and the cases that are filed tend to fall within certain very narrow ranges of challengeable conduct. And they much of the rest of the economy is left unaddressed by antitrust. So really only certain kinds of things can be successfully challenged now, and a lot of the economy is largely unregulated by the law. And so we find ourselves in a point in history in which the antitrust laws are largely ineffective and not much used. And that is the circumstances surrounding the Apple case. And so, when Apple first came out, it was a set of allegations of conduct that even under the law as it exists now, is taken to be very serious and easy to challenge. So what was challenged in the case was that the defendants were alleged to have retail products, to have done it horizontally. In other words, they set up a horizontal price fixing conspiracy. And that's the kind of conduct that is easy to challenge even nowadays under our largely unused antitrust laws, because again, there are certain narrow categories of conduct that are still prosecuted. But the thing was, even that conduct, even the most obviously illegal conduct, the easiest to challenge under the antitrust laws, struck many, many Americans as conduct that should have been left alone, that should not be illegal, and that had a good explanation. And so, the status quo as of 2012 and the background for my work was that this law has failed far enough that even the most obviously illegal conduct is finding a lot of difficulty finding popular support. And I wanted to understand why that was, how this seems to cyclically recur in the history of antitrust, and why it makes antitrust so difficult to enforce.
So can you talk a bit about the history of the case and how it relates to your bigger themes?
Yeah, sure. Okay, so the case itself. So the case involved Apple, the Apple Computer Corporation and several publishing firms, and what they were alleged to have done was fix the retail prices at which electronic books would be sold. So in 2007, by 2007, the publishing industry was in economic difficulty. I came to learn in researching the book, digging into the industry's history, that in fact the publishing industry has kind of always been on difficult times, or felt at least, or claimed that it was on hard times. But in any case, as of 2007, it did seem to be a fairly difficult period in the industry's history. Among other things, the publishers had weathered a couple of decades, basically, a very difficult adversity with their own distributors. And above all, Borders and Barnes and Noble had come to be quite powerful and demanded extremely unfavorable wholesale terms from the publishers. Before Borders and Barnes and Noble, there had been Walden Books and B. Dalton Booksellers and other economically powerful chains. So the publishers had struggled for a long time. And by 2007, they were about going on 15 years into their relationship with a new book distributor, which is Amazon, obviously. And by then, Amazon had grown quite a lot in power and had flexed its muscles quite a lot against the publishers. But the thing that happened then in 2007 was that Amazon did something the publishers weren't really expecting and definitely weren't prepared for, and that was that Amazon created the electronic books market by introducing the Kindle. So Amazon didn't invent electronic books. There had been electronic book reader products before then, but none of them had ever been successful. And in fact, most of them had been miserable commercial failures. And the Kindle was not. The Kindle was a massive success. And it was successful probably for a lot of reasons. The reader was technologically superior to things that had come before it. The Kindle also had a very large library of titles from the very beginning, which is something no reader had before than that. But probably more than anything, the real driver of the Kindle success was probably the radical pricing of the books that you could read on it. As everybody who was around then remembers, Amazon famously announced that it would sell books, including new release books by the most popular authors, at a very low price of $9.99, and Amazon was going to release them on the same day as the hardcover release. In other words, the very first day the book is available, Amazon is going to sell an alternative product at $9.99, even though the hard copy books themselves would be issued typically in the mid 30s or more. So this all caught the publishers by surprise. And that's an interesting story in itself. Amazon, it's not that the publishers didn't know it was coming. Amazon had to negotiate for the electronic rights. Obviously, it had to get the product from the publishers and negotiate the terms under which it would release them. But the publishers seem to not have taken electronic books seriously. They had bigger fish to fry, and they weren't prepared for it. And above all, they had no idea the price would be so low, or that the books would be issued on the same day as the hardcover new release. So the industry was suddenly in a very deep quandary, and saw the circumstances in existential terms. I mean, the publishers, I think, fairly sincerely believed that if they couldn't control low-price ebooks, it would threaten their own financial futures. And that, by the way, it's useful to point out the reason why low retail prices were so important to the publishers. Oftentimes, lawyers and economists will often say that low price retailers ought to actually be desirable to manufacturers most of the time. Like, if a manufacturer can get a retailer to sell a product at a low price, that's good, because other things equal, you're going to sell more units of the good, and that means more overall revenue to share between the retailer and the publisher and the manufacturer. So a lot of people ask me, why didn't the publishers love this? But the answer is very, very simple. Ebooks, even when Amazon started expanding its market share really significantly, and I guess what I should say is, Amazon started selling more and more ebooks. They started growing this market really significantly, so that ebooks were a growing portion of all book sales. But even when that was true, ebooks were still a minuscule part of book sales. And much more important to the publishers was the ability to sell those new release, best-selling hardcover books sold at a very high premium. They needed to sell the popular books at $35 that they could sell exclusively as hardcovers for a window of some months. And a lot of their profitability depended on that. So Amazon was a direct threat to that, and a very serious threat. Again, the publishers saw it in life or death terms. So over the next couple of years, the publishers engaged in a variety of steps, a variety of schemes to try to deal with the problem of Amazon. And above all, they started collaborating with one another quite a lot. So over the years between 2007 and about late 2009, the publishers started communicating a lot. And the Justice Department, in its complaint, really seemed to savor pointing this out. And in particular, the Justice Department loved dwelling on the fact that the executives of these big companies spent a lot of time meeting in very fancy restaurants in New York City, in secret rooms, and notably, they were doing it all with no lawyers present, none of the annoying general counsel staffers who might have told them that they shouldn't be talking about prices and excluding competition. So jumping ahead just a little bit, after several attempts throughout a period of a couple of years to try to get control of Amazon, to try to get it to raise prices, to try to put pressure on it, and do various other things, the publishers found that they really weren't able to move the needle at all. Interestingly, they did a couple of things during that period of years that were never the subject of any legal challenge. Like the Justice Department never didn't file any claims against them for doing this. But they did a couple of things in those years that themselves were probably like plainly illegal under the federal antitrust laws. So one thing that they did was they attempted to window the release of ebooks, meaning that they tried to collectively force Amazon to agree with them not to release ebooks for a period of whatever, 6 months or something after the issuance of a new release hardcover. But doing that by horizontal agreement amongst them, which it appears they may have done, is so obviously illegal under antitrust laws that it probably would be subject to a rule that antitrust lawyers call the rule of per se illegality, meaning that if you did the conduct, there's no defense. It's automatically illegal. Another thing they did that probably was per se illegal is interesting because it also kind of plays a role in the larger story. When the publishers first negotiated ebook rights with Amazon, as I said, they appear not to have anticipated that ebooks were going to be a big problem for them, and they didn't know that the Kindle was coming or the radical marketing strategy was going to be used, and so they gave away these rights pretty loosely. And among other things, they all seem to have given Amazon wholesale pricing terms that were quite desirable to Amazon. So by long-standing tradition in American bookselling, publishers sold hard copy books to their distributors at a wholesale discount, and the wholesale price was 50% of the list price. Or the suggested retail price of the manufacturer, the anticipated retail price. But the publishers gave Amazon a discount off that, a further discount to reflect the fact that ebook, electronic documents don't have the same production costs. It seemed only fair to give Amazon a break because the prices were, the costs were lower. And so, in other words, the wholesale price that Amazon started off with was actually roughly similar, about the same as the $9.99 price that Amazon initially sold its ebooks for. In other words, the wholesale price and the retail price that Amazon started with was basically a break-even deal. Amazon got these books at about $9.99. That's relevant to the later issues in the case because one criticism of Amazon and a criticism of the government's case against the Apple defendants was that Amazon itself must have been the real bad guy, the real anti-competitive bad guy in the story, because the critics said, the defendants in Apple and their supporters all said, look, Amazon was selling at predatorily low prices. Meaning that Amazon was selling at a loss. Well, it turns out Amazon eventually was selling ebooks at a retail price lower than the wholesale price at which it was paying for them, but only because after the Kindle was released, sometime after Amazon started selling books at $9.99, which actually was about a break-even price, about the same wholesale price that it was getting the ebooks at, the publishers all raised the wholesale price by doing away with that ebook discount that they had voluntarily given Amazon. So they pushed the price back up to the same wholesale price that they would have asked for the hard copy books. And so the wholesale price was something more like $12 or $14 for most of these books, and Amazon was still selling them at $9.99. And so it was true after a certain point that Amazon was selling ebooks at a loss off of wholesale. And the publishers loved pointing this out, and they said, look, Amazon obviously is an aggressive monopolist selling at predatorily low prices, and it's the real bad guy in the case. But that was only because the publishers raised the price. And the thing is, they seem to have done it in collaboration with each other. In other words, they seem to have gotten together and said, hey, wait a minute, our wholesale discount that we're giving this company is killing us. It's screwing us on these low prices, and let's all raise them. So in other words, it seems like there was a horizontal price fixing conspiracy even before the one the government challenged. But anyway, however that may be, none of this stuff that the publishers did seemed to make a difference. None of it could pressure Amazon into raising its retail prices. And by about late 2009, the publishers seemed to be at kind of a loss. So lo and behold, unexpectedly, out of the blue, they were approached by representatives of an entirely different industry with something of a Hail Mary salvation opportunity. And the executives in question were representatives of the Apple Corporation. So it turns out that right about the same time, Apple was in the process, just as Amazon had created the market for electronic books where many had failed before. Apple was in the process in 2009 rather, of creating another market that many had tried to create and failed, and that was tablet computing. And as we all now know, the product that Apple released eventually was the iPad, to great success. And the creators, the engineers and marketing people within Apple working on the iPad had been thinking for some time that a great product to offer on a tablet computer, a natural add-on to a tablet, would be the ability to read ebooks. The Kindle by then was already a popular product and was widely used, and so it was a natural addition to the iPad to add books. Thing is, and an interesting fact, I think, is that it appears that to Apple, ebooks were never actually that big a deal. Like the iPad surely would have been produced, it would have been released, whether it had an ebook store or not, and it probably would ultimately have been used to read books purchased from Apple, because you could do that. I mean, it was technologically feasible. Apple didn't have to become an ebook retailer on its own, but it was on Apple's mind. And above all, Steve Jobs and other leaders within Apple were cognizant of the fact. They knew that the publishers were having a difficult time with Apple, and they knew that was an opportunity. I'm sorry. They knew that the publishers were having a difficult time with Amazon, and they knew that posed an opportunity for them. That is, the publishers would work with Apple and give Apple perhaps quite desirable terms, quite profitable terms under which to sell ebooks, because they were so unhappy with Amazon. So in late 2009, Apple executives approached the publishers unsolicited and unexpected, and they proposed to them the following deal. They said, we would love to distribute your books on our new tablet product in competition with Apple. And just like you, we also don't want to sell these books at prices in competition with Amazon's current price, because it wouldn't be profitable to us. So let us work together to get those prices up. And the publishers were very, very receptive. So over the course of sort of a now legendary several weeks of breakneck negotiations, Apple representatives worked with the then 6 publishers who dominated trade publishing in English, that is, general interest publishing in English, and ultimately convinced 5 of the 6 to agree to a set of agreements that were ultimately what the government challenged in the Apple case. So the details of these agreements are kind of complicated and they got a lot of attention. But what they boil down to is really pretty simple. Basically, each of the 5 publishers agreed to a schedule of prices at which their ebooks would be sold on the iPad. And technically that left the publishers with freedom to set their prices, but it was very clear that the price they would actually charge for these books would be the highest permissible price under the contract, because the prices that were even that highest permissible price was lower than what the publishers wanted to charge. But much more important, that, by the way, in and of itself is already legally suspect. The publishers, as antitrust lawyers would say, the publishers are horizontal competitors. They're firms that are in head-to-head competition, selling the same products to the same customers. And it's very clear that you cannot agree with your horizontal competitors at what your prices are going to be. And that's true even if you've actually only agreed to some flexible schedule of prices that leaves you with freedom. You just can't do this. And again, this is the kind of conduct that's so obviously illegal that we say that it is per se illegal. There's no defense. If the government can prove that you engaged in the conduct, it's illegal. Importantly, though, the parties didn't just agree to this flexible price schedule. They also agreed that the publishers would sell their books at these prices on the iPad, but furthermore, that they wouldn't sell these books at any lower price on any other through any other retailer. And at that time, the only other major retailer was Amazon. So in effect, they agreed that they would sell at certain prices on the iPad and would sell at prices no lower on Amazon. This was a critical agreement for them to reach. It was a critical component of their agreement, because if any of them sold their price, if they sold their books at a lower price on Amazon, no one would bother buying the books on the iPad. And moreover, they all had to agree to get their prices up on Amazon, because if just one of them tried unilaterally, like imagine that Simon and Schuster agrees with Apple that it will sell a book at a certain price of, let's say, $15 on the iPad, but it simultaneously is selling its books on Amazon, and everybody else is selling their books on Amazon at $9.99. Well, Simon and Schuster could not go to Amazon and say, you have to raise your retail prices to $15 so that you're not undercutting my sales on the iPad. Amazon would just say, sorry, Charlie, go away. And people would buy, if Simon and Schuster, for example, decided, well, I'm just not going to distribute my books through Amazon anymore, then people just wouldn't buy Simon and Schuster books anymore. So it's really fundamentally critical to understand that the publishers all had to agree that they were going to work in unison and coordinate their conduct, and that they all would confront Amazon with terms under which their books would be sold at the same prices that books were sold on the iPad. Okay, so again, that's all conduct that's very, very plainly illegal under the antitrust laws if it's coordinated amongst horizontal competitors. A wrinkle in the case is that Apple was also sued as a defendant in this case. And, obviously enough, Apple is not in a horizontal relationship with those publishers. Apple is not a producer of books. It's not selling books to other distributors in competition with the publishers. Instead, Apple is in a relationship with those publishers that antitrust lawyers and economists refer to as vertical relationships. So vertical relationships are generally not subject to per se rules. They're treated much more favorably under the law, and it's much harder to challenge them. So a big bone of contention in the litigation that ultimately ensued was that was whether Apple should be treated under the same rule of per se illegality as the publishers. And there was a fair bit of litigation about that, but it turns out there's a special rule in antitrust that's designed just for this circumstance. And the rule is, if there's a horizontal conspiracy that would be subject to the per se rule, and somebody else who's not in a horizontal relationship helps to coordinate that conspiracy, intervenes and tries to help the parties agree horizontally, that person is subject to liability just as strict as the horizontal competitors. This is the so-called hub and spoke conspiracy rule, and Apple's conduct was like tailor-made to fit this rule. Okay, so when firms like these publishers go and confront Amazon, and they each individually approach, appear at the Amazon offices in Seattle and say, hey, by the way, I'm going to raise all of my ebook prices on your platform by $15. Take it or leave it, Charlie. And they each show up and they present the same terms over the course of a short period. It's pretty obvious to Amazon what has happened. That kind of thing doesn't just happen without some sort of agreement amongst the firms. And so Amazon complained to the federal authorities, and relatively quickly, the Justice Department filed a lawsuit. To make the long story of the litigation short, it was litigated to through a full trial on the merits in federal district court in New York, and the publishers actually settled before it even got to trial. Like, their conduct was so obviously illegal that they didn't even bother to litigate, and they each agreed to terms under which they wound up paying quite a lot of money to private plaintiffs and agreeing to a bunch of limitations on their conduct with the government. Apple, though, stuck it out the whole way to the very bitter end. And that's actually kind of an interesting question in itself, an interesting story. Like, why Apple's conduct was also pretty plainly illegal, and it's a bit of a mystery why they stuck it out so long. And I don't really know the answer to that question, but they did, and they litigated all the way through the trial. They lost really emphatically in a long written opinion. The judge said that the evidence, like a half a dozen times, the judge said the evidence against Apple was overwhelming, and applied the per se rule and found it liable. Apple appealed, lost before the Intermediate Court of Appeals. The Supreme Court declined to hear the case. So ultimately, Apple lost roundly and comprehensively. In separate private litigation, Apple wound up agreeing to money damages settlement that ultimately amounted to about $500 million. And Apple paid damages in litigation in other countries, in Canada and in Europe. And ultimately, the thing cost Apple many hundreds of millions of dollars. Okay, well, anyway, so, that's the case. I mean, like I said, it wasn't the case itself that was really so interesting. It was the fact that so many people found it so hard to believe in the case. And there's so much we could say about that, but the real bottom line for so many people seems to have been, for one thing, many people thought that the real problem in the case was Amazon. Surely Amazon is also a competitive threat. And many people thought, the real bad guy here is the one guy that the government didn't sue, and maybe worse yet, the government suing Apple and the publishers really just helped Amazon become an even bigger monopoly. So that was a huge problem for a lot of people. But lots of other defenses of the defendants came up, lots of other arguments for why there shouldn't be antitrust liability. In the end, what seemed to unite a lot of criticism, the many criticisms, which again came from all across the political spectrum. They came from the left and the right. What seemed to unite people was the sense that the real problem in the case was that price competition itself was too vigorous, and that under the special circumstances of this case, the price competition that we ordinarily take as important and useful and sort of like the mechanism by which markets do their work. Under the special circumstances of this case, a lot of people thought you have to protect these defendants from it, or else serious social losses will follow. And so that ultimately is what the book came to be about. After talking about the case and the issues it poses, I try to address those big questions, like I try to work through the specific arguments that are raised. Are the specific arguments that so many people made that the real problem in the case was price competition itself? Do they persuade? And my position in the book is, first of all, these arguments aren't really very persuasive. Some strike me as more persuasive than others, but none of them really seem like an especially good reason to let a price-fixing cartel flourish, or to take the place of markets as our regulator. And moreover, none of the arguments seemed like they were particularly special to the Apple case. Like, nothing about this case really justified saying that price competition here is different somehow than it is in other circumstances, and we have to let defendants shield themselves from it. And that's the book.
So talk a little bit about antitrust and its discontents. Particularly within your book, you write that markets in their ordinary operation are machines for producing pain. I quite like that quote.
Yeah.
Why is this important when we talk about antitrust?
Yeah, so that's good. I mean, that really gets right to the heart of the tension that I was just talking about. So, the point of that observation is that we say in America that we like markets, or we at least believe in markets enough to tolerate them to do most of our regulatory work. But the reason that I don't think we're very good at actually following through with that idea and putting our money where our mouth is that markets are actually pretty ugly machine, pretty ugly to watch in their ordinary operation. They generate business failures. They generate job losses. They generate lost investments. It's a nasty business to be in competition, but it also does important work. And having an antitrust law really means. So, I mean, however you want to look at it, different people have different ideas about what antitrust should be. But most ideas of a competition policy in one way or another boil down to having rules that are supposed to protect those markets and make them work, because it's ultimately the markets that have to organize our economy. So that the problem, though, is the problem that came up in Apple. So they're ugly to watch. So a lot of specific problems come up, and come to be the basis of popular discontent, popular lack of support for competition policy. So, just to take examples from the Apple case itself, a common theme that the publishers raised, a common argument they made, and a common basis on which the broader public supported the publishers was their belief that Amazon was going to put them out of business. They said, these low prices are going to kill us. If we can't make more, if we're forced to lower our hardcover prices as far as Amazon wants them to be, if we have to meet competition with products that are sold at $9.99, we won't be able to cover our costs and we'll go out of business. And so, that poses an obvious and immediate problem, obvious question about competition policy. If we're going to support this policy, does it mean we have to let businesses fail? And to a lot of people, that can be a pretty sensitive question. I mean, to me, I think that's it's a question that's poses serious sympathetic regrets in a lot of ways. But on the other hand, if we're going to have, the most basic idea in our economic theory is that if a firm can't compete on a cost basis with other firms in the market, then it's supposed to fail. Businesses, less efficient businesses exiting is what's supposed to happen. So, I mean, that's just one example. It's a poignant problem. It's not what I mean to minimize. And the losses are real. But on the other hand, we kind of have to have them if we're going to have markets at all. And the alternative to not having markets do the work, I think, are more disappointing yet. So, I mean, that's the problem in a nutshell. The discontents, the various arguments, the various other arguments that unrestrained price competition is a problem. They get more sophisticated than that, and they oftentimes get more, generate more sympathy than that, generate more serious concern than that. But in the end, they all boil down to the same problem for me, which is that markets actually do important things, and they do them better than other alternatives that we've got. And it's better for us to let them do what they can than to try to avoid the problems that they generate.
So talk a little bit about industries claiming that they're part of special markets and why that matters or not. And are there any markets that need the special treatment that they ask for?
Yeah, I mean, that's a good question. So like I said, all kinds of industries have made arguments like this throughout the whole history of the law. Some more plausibly than others. But, from the very beginning of the law, there were firms arguing that something about their products or something about their particular markets required that they have some kind of protection from vigorous competition. One of the most famous examples of that from a very important case early in the law, it was litigated in the late 1890s, was a case that involved cast iron sewer pipes. The firms in that market, in that case, said, look, the nature of our technology, courts, is special, and we can't produce these products under vigorous competition. So, from the very beginning and amongst firms in extremely mundane markets, we've seen all across the economy people saying that their markets have to be protected from competition or they can't survive. So, I mean, are there any markets now that make a plausible claim that they need some kind of special protection? And my answer is not really. I mean, I've spent much of my career studying this particular issue, studying the special rules that govern markets with products that seem special. And very rarely can you find solid economic evidence that some particular technology or the circumstances of some particular market mean that the product can't be produced under competition. Plausible candidates might include electricity, which turns out to be a very weird product in a lot of ways. Insurance has certain economic weirdnesses. But generally speaking, no. I mean, fairly often firms have, all kinds of firms have made this argument. Sometimes firms are able to persuade the courts or sometimes Congress that they should get some sort of special clemency. But what almost always happens, the few dozen times that this has been done throughout antitrust history, what almost always happens is that the firms that complained they needed some protection from competition, when they get it, when they get like some statutory antitrust exemption or something, they don't do any better without exposure to antitrust, and oftentimes they do worse. And so there's usually no real benefit from it and some serious harm. So in the end, it seems like competition is kind of the best we have to hope for.
So what about the impacts of the digital transition?
Yeah, I mean that's a good question too. I mean that goes to the problem of whether any markets are special. The digital transition was a big deal. I suppose it definitely was a big deal in the local sense that for individual firms that had been producing with pre-digital technology, the transition to digital distribution of things was economically painful. In the end, I mean, I think technological change, technological transition, it gets a lot of attention, and especially in the last 10 or 20 years, we've talked a lot about disruptive technology and disruptive entry and so on, and the magical properties that it's supposed to have. But really, technological innovation, any other kind of innovation, they're really just aspects of competition. I mean, the chief feature of a technological innovation that causes disruption is just that it allows some firms to sell a product more cheaply or at higher quality, and that's literally just price competition. So I don't think there's anything actually all that special about it. And again, a major theme in the Apple case was precisely this: that there must be something special about technological innovation, and the threat it poses to settled interests and cultural values and so on, that says that we have to have protection from unbridled competition in a case like the Apple case. But in the end, it just really did not persuade at all. I think that markets will adjust, and they'll adjust in ways that will be, on the whole, beneficial to society. And so, what happens when there's lower price, or better quality competition because of a technological innovation like digital distribution is exactly what's supposed to happen. And the last thing we should do is try to control it with a horizontal price fixing conspiracy.
So you seem to want to preserve current antitrust, at least in general terms. But are there any ways that you think it should be reformed or changed?
Well, definitely. I mean, I don't think that anything about current circumstances um, require us to amend the law or change antitrust in any very significant paradigmatic kind of way. What we do actually need to do, though, is just enforce the laws we've got. And above all, a couple of aspects of our antitrust law are essentially unenforced right now, which is our merger law. We let way too many big mergers go through, and we have essentially no monopolization law. We don't sue big companies who are dangerous just for their own unilateral actions.
So, talking about monopolization, let's talk about Amazon as monopoly, the case and why that matters, and about public opinion in general when it comes to a monopolization rule that could apply to Amazon or another similarly situated large company.
Yeah, no, this is good. So, it's very interesting because a lot of people think the whole problem or the biggest problem anyway with our antitrust as it currently exists is that it's not well designed to handle firms like Amazon. It can't handle new economy firms, and in particular, our monopolization law isn't up to the task of dealing with the great big tech firms that we've got right now. So, just as a little background observation, antitrust, American antitrust basically makes three different things illegal. It's illegal to conspire with your competitors in ways that limit competition. It's also illegal to engage in unilateral conduct or monopolization in ways that injure competition if you're a big enough firm. So if you're a big firm and you take unilateral action that excludes competitors, that can violate the law, and that's called monopolization. And then it's also illegal to engage in mergers or acquisitions that give you monopoly power. So that monopolization piece um, is definitely a problem. It's definitely a sore spot in our existing law. It's very difficult to enforce the rule that we've got. And above all, the courts require, American courts anyway, require a plaintiff to prove that a firm has an extraordinarily large amount of market power before we can challenge it for its unilateral conduct. Um, and that's largely what makes it so difficult. So basically, with a firm like Amazon, to challenge it under a monopolization theory, you're going to have to show that it has probably like 80 to 90% of some particular market. And, a surprising fact that I think a lot of people don't know is that in really none of Amazon's markets, as markets are traditionally conceived, does it have anything like that kind of market share. So it is definitely a very big firm, and it does have big market shares in a fair number of markets. But for example, we think of Amazon as a retail monopolist, like it must be this 100-pound gorilla in all retail. But it turns out that in retail overall, Amazon only has about 5%. And even in online retail, where Amazon definitely is by far the biggest player, it only has about 50%. So a big problem in suing Amazon is going to be figuring out where it is that Amazon has the kind of market power that can support a monopolization claim. I think, but this is a nice example, I think, of why I believe we can address the problems we've got with the law that we've got. So it just calls for a little creativity and a little increased judicial willingness to actually enforce the law. So what I have in mind with Amazon is, well, there are ways we can creatively understand Amazon's market power. We have to ask, what is the thing that makes Amazon the must-have distributor? Like, why is it that suppliers of retail goods seem to find that they can't say no to Amazon and they have to agree to whatever terms that it wants? And if we can figure out why that is, maybe then we can define some relevant market in which Amazon really does have monopoly power. And I think the answer is that Amazon is the must-have firm, because the must-have distributor, because it can do things that no other distributors can do. It can get products to consumers in their homes a day or two after they purchase them. So, if there is a market for next day in-home delivery, I have a feeling that, and if we can convince a court to define a relevant market that way, I have a feeling that Amazon is going to be found to have an extraordinarily large share of that market. And if you can show that Amazon did things that were exclusionary in a way that's illegal to get that great big market share in next day home delivery or something like that, then there's maybe a viable monopolization case. A point of this discussion, though, something to keep in mind is that's all really very different than what I've just described as a viable a monopolization theory against Amazon is very different than what Amazon was alleged to have done in the ebooks case. I kind of hate to talk about this kind of thing in this way because I come off sounding like Robert Bork or something. But the truth is that Amazon did stuff in the ebooks case that to many people looked like monopolization, looked like anti-competitive, overly vigorous, predatory conduct meant to kill off competitors with the goal of getting a monopoly, that I don't think were anti-competitive at all. In fact, I think they were the soul of competition. They were exactly what we want firms to do, and the social benefits are large. Specifically, Amazon took electronic books. It sold them at as I said earlier in this conversation, its prices, even though they were radically low, they were basically break-even low. Amazon wasn't selling at a loss to get a monopoly. And it gave people these sort of magically new, technologically innovative products that nobody had ever had before at extraordinarily low prices. And despite all the arguments that came up in the case, the arguments for dangers to the publishers and dangers to authors and dangers to literature itself and the end of the paper book and so on, it seems to me are hugely outweighed by the benefits of what Amazon brought to people. So I guess the point of that is, do I think Amazon could be the subject of a monopolization challenge? Do I think it's a problem? Emphatically, yes. I do think that Amazon is a serious problem. It's a dangerous firm that poses a lot of threats to society, and it has to be taken seriously. But we can't, and we shouldn't just say that it seems real big and we ought to break it up, or it seems real big and we ought to keep it from doing what it does. I think instead we have to think carefully about the ways that it actually hurts people or could, and sue it for those things.
Can you talk a little bit about anti-bigness rules and potential solutions to our current antitrust problems, and a little bit about no-fault monopolization rules?
Yeah. Okay. So, I mean, a little bit at odds with something I just said is, an alternative is we could have anti-bigness rules. We've essentially never had those in the United States. In other words, we've never had a law that said firms can only get so big, or that once a firm gets to a certain size, the government will break it up. That's what we might refer to as a no-fault monopolization rule, or something like that, an affirmative deconcentration rule. We've essentially never had them. So some people are calling for those things right now. The sort of the most left progressive wing of antitrust activism right now definitely favors no-fault corporate breakup rules. And what's a little bit at odds with what I said earlier is I actually think that would be okay. I think if we could have a no-fault monopolization rule, it might be just fine. The truth is, there's no very good economic argument in theory or with any empirical basis that firms have to be very large in order to operate efficiently. So in many circumstances, if we're just breaking up a firm into smaller pieces, that's probably actually desirable, and so it would be okay. The problem, is it's laughably implausible as a political matter that we're going to have any law like that in the foreseeable future. The United States is not going to adopt a no-fault monopoly rule. We did actually come close to adopting rules like that in the late 1960s, the early 70s, but that's 50 years ago, and the world's changed a lot, and we're just not going to be able to pull this off.
A major point you make in the book is that discontent with antitrust and with the idea of markets as regulators animates critics on both the left and the right. So can you talk a little bit specifically about Lester Tester's free riding argument and how that affected economic thinking?
Yeah. So this is like one of my favorite parts of the books, one of my favorite insights, and the most important thing to me in the book. It is true that the same arguments, it seems to me, the same arguments or implicitly similar seeming arguments about the Apple case seem to keep coming from both the left and the right. And in fact, the left and the right were both awfully concerned with Amazon, with the problem of Amazon. And in fact, there were some fairly surprising moments in the history of the case in which people who never, ever talk like this were talking about Amazon as if the real problem in the world was corporate bigness and giant firms that can charge very low prices. I heard those arguments from the usual suspects. I mean, I heard it from very left-leaning progressive activists, and I expect to hear that from them. But I also heard it from like big law defense lawyers, the kind of people who usually say the bigness of a firm is irrelevant. No firm should ever be broken up just because it's so big. And low prices are the best thing ever. So it was amazing to me that very conservative seeming people were saying that the real problem in the case was Amazon. And more generally, I heard similar kinds of arguments from the left and the right across the spectrum. And the bottom line for me is it seemed like all these arguments really were in one way or another tied to the idea that sometimes vigorous competition itself, and specifically vigorous price competition, is the real enemy. And it dawned on me in writing this book just how often that argument is made by people who are very conservative. And so that leads, to the ultimate conclusion of my book, which is the real problem and the real difficulty in enforcing antitrust law is that people just don't really believe in markets. We all in America, generally speaking, claim to, but we really don't. Okay, so the relevance of Lester Telser to this, this is a little bit in the weeds, but it was a useful example in the book because it's a nice example of how often very conservative critics, very conservative perspectives, arguments from the kind of people that we usually think of as free market zealots, like people who believe that markets are extraordinarily powerful and self-regulatory. It was a nice example of how often, when it suits them politically, they too are willing to say that in fact markets are susceptible to failures of various kinds, and ultimately that markets can fail because vigorous price competition itself is the bad guy. So Telser is a economist associated with the University of Chicago, and he's famous for a few things, but probably his biggest contribution was an argument about a certain kind of distribution policy. So a problem comes up in antitrust sometimes when a manufacturer tries to control the prices at which its own retailers will resell the manufacturer's goods. So if you can imagine an auto manufacturer setting prices by resale prices with its car lot distributors. Under antitrust law, at least in principle, that can be illegal. So that's a vertical relationship. As I said before, if a manufacturer reaches an agreement with its own distributors, that's not a horizontal relationship, it's vertical. And generally speaking, vertical relationships are harder to challenge under the law. But the law has always said that vertical agreements can be illegal. And in particular, when manufacturers fix resale prices with their retailers through contract, that vertical agreement at some points in our history was treated as fairly suspect. And for a while, it was those kind of agreements were flatly illegal. So Telser made a contribution, though, which was an argument for why those kinds of agreements might actually be desirable, like why antitrust ought to tolerate those things, why they might be socially desirable. And his argument was an economic argument. And I don't want to get too far in the weeds, but basically he explained that sometimes manufacturers might want their retailers to charge higher retail prices. Okay, and again, I don't want to get too complicated here, but generally speaking, you would expect manufacturers to like retailers to set lower retail prices. The lower the retail prices are, other things being equal, the more units will be sold, and the manufacturer wants to sell more units and make more revenue. So it's kind of curious that you nevertheless see manufacturers sometimes agreeing to retail price agreements with their distributors. And Telser came up with this argument for why they might want to do that. And basically his argument was sometimes manufacturers want retailers to actually invest their own money, invest substantial amounts of their own money in marketing the product. So the manufacturer might want retailers to have like fancy showrooms and well-educated sales staff who have lots of time to spend with customers and stuff, and all that's very expensive. And Telser said, if any retailer can set any retail price they want, that could pose a real problem, because if one retailer is investing in all the fancy marketing pizzazz, but other retailers can sell the same products at discount prices, well, maybe customers will go to the fancy retailer, eat up all of their sales staff's time and resources, but then not buy the product there and go buy it at the discount retailer once they've learned about it and realized that they want to buy the product. So that's the argument for free riding. The discount retailer might take a free ride on the investments made by the higher quality retailer. And so it could be bad for society if price competition has the result of causing the higher cost retailers not to make those investments anymore, because maybe consumers benefit from having the higher caliber marketing efforts. Okay, so that's all kind of complicated and in the weeds and stuff, but it had a really nice key relevance for my book, because Telser is at the leading, he was a leader amongst the very conservative economists and lawyers that we think of as the Chicago School of Economics, the Chicago School of Antitrust Law. And he was among the leaders who led that revolution in the mid-1970s that has resulted in antitrust largely being dead. And so this is all, excuse me, fairly ironic, because that group, the Chicago School, are notoriously the most zealous free market advocates there are. And generally speaking, their argument that we don't need antitrust and we don't need government intervention is that markets themselves are so powerfully regulatory that they don't need the assistance of antitrust law. But it seems to me that when it's useful, that is, when it makes a nice argument that the government should let private people restrain their markets, conservative economists are more than happy to argue that markets in that case are unable to give consumers what they want under the under the pressure of vigorous price competition. And that's exactly what happened with the free riding argument. The argument is that if retailers can engage in vigorous price competition, then the higher caliber retailers won't be able to offer innovative or expensive marketing and informational services, even if consumers want them. So that kind of flies right in the face of believing that markets themselves are self-regulatory or robust, or whatever the kind of arguments that conservative economists generally take to very strongly. And the ultimate point in observing that was just the same as the ultimate point of the book, which was, when push comes to shove, however much we say that we believe in markets, people don't actually believe in markets very much at all. And in particular, when we see individual cases of markets in operation, and in particular, when the government is asked to intervene with the antitrust laws to ensure that those markets stay vigorous, that's when we see people all across the political spectrum coming up with reasons that, in fact, price competition itself is the whole problem. And we can't have faith that these markets can protect values that we care about without some kind of interference. And that's kind of the end point of the book. I mean, it's very hard to find some coalition of broad consensus that says, sure, we can believe that markets are actually the right thing to do in this circumstance. And that's why ultimately I think that antitrust has largely been ineffective.
So let's talk about another Chicago School thinker, Ronald Coase, who talked about an assertion about the preoccupation with the monopoly problem.
Yeah.
How does that relate to this issue?
Yeah. One of my favorite quotes in history. So Coase, he was a wit. I think he was very witty, and he was good at coming up with sassy put downs. And in that quote, he was taking to task the other economists of his day. It's kind of hard to remember it this way now because economics seems like it's mostly a conservative force, I think, to most people now. But in the mid 20th century, many economists were actually strongly in favor of really vigorous antitrust enforcement, and they believed that monopoly was prevalent and was a real problem. And Coase did not agree. And in that famous quote, he said that economists, I'm paraphrasing, but economists of his day were so preoccupied with the monopoly problem that whenever they found some practice, some circumstances in a market that they didn't understand, they reached for a monopoly solution. And he says, since we are so ignorant in so many areas and there are so many ununderstandable problems, monopoly solutions are very prevalent. So he was making fun of those people, obviously. He was saying that because you're ignorant, you're jumping to your own political biases. The point of pointing that out for me in the book is that I think the shoe is now completely on the other foot. Like we've flipped that completely 180 degrees. And so now most economists and most antitrust observers and surely most of the federal judiciary are so sure that monopoly can't happen, that monopoly is not a problem, that they will bend over backwards looking for any explanation, no matter how convoluted or complex or tortuous, to show that some challenged conduct in an antitrust case, to show that it's harmless. That they will do that even when the most obvious explanation is that these guys are just conspiring against the public interest. They're engaged in a competitive conduct. And that was the case in Apple. I mean, Apple was an easy case. Like I said, it's a horizontal price fix conspiracy coordinated by a distributor, Apple, that had a clear interest in raising prices across the board for no plausible reason except to make more money for its shareholders. And yet, very smart lawyers and economists from all over the spectrum went way out of their way coming up with really complicated arguments for why this was in fact somehow beneficial and it just plainly was not.
Let's finally talk about something that's a little further in the past, the 19th century Methudenstreit, or for German-speaking countries, Methudenstreit der Nationaleconomie.
Yeah. I probably say it wrong, but you said it better than I do. So that was the classic conflict in European economics of the mid 19th century. And this figures in the book. I mean, like I said, I started off with this one narrow case, and the book got bigger and bigger and bigger, and I dig way into a lot of historical background. And the conflict of the 19th century amongst economists was very interesting because it really goes to the heart of the Apple case itself and the tensions that I saw in it, and ultimately the conflict between the differing perspectives in that case. The differing perspectives were economists in Germany who in the 19th century German universities were really dominant. They were the leading universities in the world, and German economists were leaders worldwide. But the dominant view in Germany was very different than the dominant view in England and America. Economists in England, in particular, looked at the world quite differently. England at the time was sort of the other dominant force in economic theory. And the basic difference between them, the difference between English economists and German economists was basically a problem of generalization. The tension was over how useful it might be to generalize, to try to come up with theoretical generalizations that abstracted away from the detail of specific worldly cases. So the Germans, the dominant school in Germany was known as the historical school of economic thought. And the German historical school believed that you couldn't look at economic problems without understanding the whole history and the context of whatever industry you were looking at. And the English obviously were a different animal entirely. They thought the whole point of theoretical speculation ought to be to come up with the broadest generalizations that you could safely make. Like you purchase explanatory power by abstracting away from details. So that tension is a big tension in that still exists, and it is reflected very, very powerfully in not just the economics of antitrust law, but in antitrust law itself. Because just like in in that old conflict, a big question is, well, how general can we make our rules? Like, how generally applicable can we make antitrust rules without allowing people to have exceptions or exemptions for purportedly special circumstances? And that's the tension of my book. And I say, I think actually we can safely generalize pretty far. We don't really benefit that much from coming up with antitrust clemencies every time we think that there might be something special about a market. And I say that basically because I think that the things that seem special are not so much features of individual markets that make them different than other ones. The things that seem special in any particular market, when we look at the effects of competition there, are really just the ordinary incidents of competition causing pain. So if competition causes business failures or job losses or lost investments or whatever, it may seem like there has to be something special about that market, but the odds are it's just competition doing what it does.
For the German listeners of the podcast, I would like to apologize ahead of time in case I mispronounced Methudenstreit.
Yeah.
I would like to note that German is not my first language.
Well, I'm much wiser than you, Luce. I didn't try to say it because I knew I would.
I'd like to note any mispronunciation is solely my fault. I would like to, however, defend myself by saying that German is my 7th language.
Oh, Jesus. Okay.
Let's talk about retail price management, what it is and how it applies to the case.
Yeah. Okay. So really, we've kind of already talked about it. Resale price maintenance is just the agreement amongst between a manufacturer and its retailer to set retail prices. It used to be illegal pretty broadly. Now it's pretty broadly legal. It was relevant to the case. And by the way, this is what Lester Telser was talking about. So the whole economics that Telser generated of free riding was all an argument about why resale price maintenance might be actually a good thing. The reason it was relevant to the case was there's a long history of law and politics surrounding resale price maintenance in antitrust, in which the courts have come to believe that resale price maintenance ought to be broadly tolerated, that in fact it's probably a good thing. And so it's taken as like a really big victory of conservative antitrust agitation to have persuaded the courts that all of that is true, and having convinced them to make resale price maintenance largely legal. That was relevant to the Apple case because nowadays that agitation, that history of agitation in favor of vertical restraints and resale price maintenance was so successful that nowadays every antitrust defendant that can plausibly characterize itself as being in a vertical relationship makes a big point of saying, hey, we're just like those RPM defendants of the 70s and 80s that the courts said were actually doing society a favor. So that played a big role in Apple. The Apple company said, hey, look, we're not involved in a horizontal conspiracy. We're just horizontal. We're just vertical. Distributors and all the restraints we adopted were for the benefit of society. And that found a lot of supporters amongst conservatives. Didn't persuade the courts, and in fact, I think it was kind of a crock.
Can you talk a little bit about the history of the book market and book cartels?
Yeah, sure. So an interesting thing was, the the Apple people, the Apple defendants, and the supporters they found talked a lot about how the case was new or the case was special, and that was a big part of the argument that it ought to be the defendants ought to get some sort of special clemency. But it turns out that there's actually quite a history of cartels and vertical price maintenance in books. Publishers, something I said earlier was publishers have actually been complaining about their economic problems for a really long time. There's a famous story. I believe the journalist Ken Auletta told this story. A editor at one publishing house told him that at their company, they joked that the second book published on the Gutenberg printing press was a story about the death of the publishing industry. So they've been complaining about this forever. And one thing they've been doing forever to try to protect themselves from the problems they perceive is they've been fixing prices with their retail distributors. So publishers and booksellers have been engaged in price cartels for about 200 years, as it turns out. And in fact, a conspiracy really just like the one in the Apple case was actually adopted in England around the turn of the 20th century, and it was enforced for almost a century. So just one more big piece of evidence that, first of all, the financial distress the publishers faced around 2007 wasn't actually new, and second, that the Apple conspiracy itself wasn't some sort of special new circumstance needed to deal with technological disruption or anything else.
So do you have any final thoughts wrapping all of this together?
Yeah, I mean, that was a lot of territory. We talked forever, and we talked about a lot of different things. But I mean, the bottom line for me is the book is all about the tension between the general and the specific, and the need that I think we have as a society to avoid the temptation to believe that particular cases, specific cases, are somehow special, and that we really can treat our vision of competition as generally applicable.
So as a final question, what would you like your fellow scholars, listeners of this podcast, and policymakers to take away from your comments and your book in general?
Well, I don't know. A lot of things, I guess. I mean, I hope it's a good read. And I hope, above all, though, that people, the deepest contribution I want to make, the deepest theoretical insight that I think is in the book, is just how broadly held is this suspicion or fear of price competition itself, and how generalized it is all across the ideological spectrum. I think that if we, I'm not sure how much I even believe this is really something to hope for, but if we could generally overcome that problem and just believe that markets, even as ugly as they are, really are the best choice in most circumstances, we could finally have an antitrust law that actually works.
All right. Well, thank you very much, Chris, for coming on the podcast to talk about your excellent book, United States v. Apple, Competition in America, available online and at a academic bookstore near you, and apparently on these as an ebook as well.
Oh, yeah.
Which is fitting.
Yes, it is. All right. Thanks so much, Liz. Good night.
He took half the money that was earned in some far distant land, gave back half to Larry, and I end up with half of goodness knows what. on the verge of a nervous breakdown, I decided to fight right to the end. But if I ever get my money